afternoon, everyone, and welcome to today's webinar. Supreme Court has its say on developers' bad behaviour, the Alexander Devine Children's Cancer Trust and Housing Associations Limited. My name is Stephen Smith, and I'm absolutely thrilled today to be joined once again by our regular speaker in Quayle, but also a special guest speaker, Paul Greatholder. I'm sure that most of you are aware that Paul advised and acted successfully for the Alexander Devine Children's Cancer Trust in this leading Supreme Court case. So it is an honour to have him with us today to discuss certain aspects of the case and considerations for what this might mean for future developments where land is encumbered by restrictive covenants. Before I hand over to Ian and Paul, I'd just quickly like to go over a few items so that you know how to participate in today's event. You are listening through your computer speaker system by default, but if you would prefer to log on via the phone, you can just select the telephone option in the audio pane and the dial-in information will be displayed. I've been reliably informed that this is toll-free and the reception is very, very clear through the telephone if you wish to do that. You will have the opportunity to submit text questions to both Ian and Paul by typing your questions in the questions pane of your control panel. You can send your questions at any point during the presentation, but we will collect these together and have a designated Q&A session at the end of today's presentation. You can, if you wish, also raise your hand during the presentation if you're having any difficulties with the sound or other technical issues. Of course, if you would also like to speak to Ian, either Ian or Paul during their presentation, you can do so. Please just raise your hand, leave me a note that you'd like to ask the question over your microphone and we can arrange that too. Without further ado, anyway, I will pass you on to Ian and Paul for the main part of today's presentation and discussion. Thanks, Ian and Paul, over to you.
Thank you. Thank you very much, Stephen. Thank you everyone for coming along today. And again, thanks for Stewart Title for setting this up. And of course, Paul, thanks very much for coming along today. I know you're a busy guy. It's lovely to have a proper property litigator alongside me today. It's great news. So Paul, I've got a few questions that I'd like to ask as far as delegates that are listening in or watching in, they may have some questions as well, which we'll deal with as we progress. But just to sort of start the ball rolling, I'm always interested in property litigators. How did you get this case? What happened? What's the backstory, Paul, if you don't mind?
Thanks very much, Ian, and thanks to Stewart Title for inviting me to speak here. Yeah, so the backstory, a few things came together quite well. We as a firm do a lot of representation of charities and not-for-profit organisations. We also do a lot of work on restrictive covenants, so this was well within our comfort zone. And then most importantly, I was introduced to the client by the barrister who had represented Alexander Devine in the first two rounds of litigation. So as people generally know, there was an upper tribunal round, there was a Court of Appeal round, and at that point, Alex Devine had won. And the barrister brought me in to work with the client to see what its remedies might be. And I went over to Maidenhead, I met the client, I met the trustees, walked around the site, and I thought we'd gel, I thought we'd get on. One thing I want to say straight away as well was this was one of those very unusual situations. I don't want to be cynical about it, where my client was in the middle of a litigation and had done absolutely nothing wrong at all. It was a children's cancer charity. The neighbouring developer had gone ahead and built, and then the neighbouring developer had dragged my client into the litigation. So I instinctively felt, well, actually, there's something to go into battle for here. So so that's how I got involved. That was 2 years ago, almost exactly to the day. And when we got the judgment in November. So I've been involved for a couple of years.
Right, but a nice client to deal with, given the fact that you know, you were in a situation where they appeared to have done nothing wrong, from what you said, yeah.
Absolutely. I mean, the backstory is, you know, quite inspiring, really. That Fiona Devine and her husband set up this charity a few years ago to provide children's hospice care, and they'd been given some land in Maidenhead, and right next door to that land was some disused industrial land, and that's where Millgate, who were the other main party in the early stages, went ahead and built their housing estate. So I, amongst other things, I could go and see the development of my client's building, the opening of it, really quite sort of emotional stuff, and I could see how important it was for my clients that they got the right result from this case.
Yeah. Because you do quite a bit of charity work, do you? A lot of work for charities and things.
Yes, about 15 years ago, we merged with a specialist charity firm, and since then I've done a great deal of work for charities large and small, and quite often their problems are the same as companies or as individuals, and certainly in relation to restrictive covenants, Ian, that's been one of the interesting angles of this, is that it really doesn't matter who you are as a party. It doesn't matter whether you're a charity, a company, an individual. If you own property, then you might need to consider restrictive covenants and how they affect your land. So there's a sort of universal relevance there.
Sorry, Paul, I think we may have lost Ian on reception there. So, yeah, we'll just try and get Ian back. But I don't know if you want to continue talking a bit more about the details of the case itself and the process through the Supreme Court, I guess.
I'm happy to speak about that if you want to there, Steve. Shall I do that?
Yes, I think so. We'll just continue there.
Okay, well, the progress of the case, without getting into too much very dull litigation detail, was that the first that my client, the charity, learned about the fact that there was a restrictive covenant over its land was when it received the proceedings issued by the neighbouring developer. And the neighbouring developer owned this site. It was the subject of a restrictive covenant, and they'd gone and built on it. And then they applied to the upper tribunal, which is sort of specialist property court, for that restrictive covenant to be removed. And what happened in the upper tribunal was quite interesting, because ultimately that was what the Supreme Court had to review. But in essence, the upper tribunal had to look at whether Millgate, who was the developer, had met the necessary criteria. Hello again, Ian, can you hear? I'll carry on for the moment, Steve, if that's okay.
Can you hear me,
Yes,
Paul?
of course, no problem.
Hello, Ian, can you hear me?
Hi, Paul. Yes, I can, loud and clear. Sorry about that. I lost connection. So, Paul, what I was saying is you do quite a lot of charity work, so this wasn't an unusual sort of transaction for you to get involved in, or dispute for you to get involved in.
I do act for a lot of charities. Quite often their problems crop up, and they need resolving sensitively, commercially. But in relation to restrictive covenants, they're standard problems, whether you're buying and selling residential property, or whether you are a big commercial developer who needs to consider a range of things, a restrictive covenant may be an issue for you there.
Yeah.
While you were offline, I was just ploughing through a little bit of the history of it, just explaining how in the upper tribunal to start with, Ian, the developer had effectively won, although the tribunal had clearly taken a pretty dim view of what the developer had done, which was building out this housing estate and only then seeking to get it the restrictive covenant modified. Yeah. And so that was round one, and then round two, an appeal to the Court of Appeal, where interestingly the developer lost very, very badly. There was an overwhelming judgment in favour of my client Alex Devine. However, what the Supreme Court said in its decision, and what we'll come on to, is that in fact this Court of Appeal didn't really get it right.
Okay.
The Supreme Court found that the upper tribunal was wrong. It was wrong. It didn't reach the right decision, but for the wrong reasons that the Court of Appeal found. So my involvement's really been working with the client through the Supreme Court case, understanding what the legal issues were, what the practical ones were, and basically helping it win.
Yeah. So really, from a practitioner's point of view, Paul, we should be focusing in on what the Supreme Court had to say. That's really where the significant issues are. Yeah.
Yeah. So there are two generally important points that come out of this decision of a sort of legal nature. But before I get onto those, one thing that I would want to emphasise is there's been quite a lot of coverage about this case, and almost all of it has been critical of the developer. And what I would want to say is this case is not anti-development at all. What this case is about is the behaviour of a particular developer. It wasn't personal, it was just saying that the way that they had done this was regrettable. So it's not anti-development, and in many ways it's quite helpful for developers. But the two key points from the Supreme Court case were, when do you look at the behaviour of a party who's asking for the court's indulgence or tribunal's indulgence to have a restrictive covenant removed? When do you do that? Because there's a two-stage test in order to get a covenant removed, and the first one is technically, have you made out some sort of case, some sort of legal basis for doing it, and the usual legal bases for getting a restrictive covenant varied or removed are that the other parties agreed to have it removed. Well, that's not the case here. That it doesn't actually help the other party. Well, that wasn't the case here. That it doesn't secure any benefit for the other party. Well, this covenant did secure benefit. And finally, the question of whether it's in the public interest for the covenant to be removed. And what this case is, the legal issue was really about that public interest. And what the Supreme Court said was, when it's asking the question, what's in the public interest, it's not looking at the behaviour of the developer at that stage.
Yes.
So where the Court of Appeal had gone a little bit wrong was it had said, in working out what the public interest is, we need to have a look at whether the developers behave terribly or not. And the Supreme Court said, no, that's not the right time to ask that question. What you need to do is look at things like whether planning permission had been granted. You need to look at whether there was a need for housing in that particular area. So those sort of objective things. So when people were advising their developer clients, those are the sorts of things they need to be saying is, actually, we need to tick these boxes. You need to get your planning permission. You need to show that there's a public interest in having these houses built. So that was the first thing.
So Paul, what we're saying is that's very useful from a developer's perspective, isn't it?
Yeah. It makes it, I think, and a lot of commentators think, it makes it much more certain for a developer to be able to get over that initial hurdle, to be able to say, I've done my due diligence here, I've got planning permission, I have checked out what the local development plan is, all those sorts of things, and I know what the public interest is. So that's helpful to developers. So question one is, could I get the restrictive covenant removed? And the second question, and this is what seems to have got the most coverage, is should I get it removed? And that's where the question of the developer's behaviour was absolutely key, because the first test, sorry, my lights have gone off there, I've been too immobile for long. The second test is even if the developer has made out its ground, are there reasons why the court should exercise its discretion not to release the covenant? And that's where Millgate, the original developer, fell foul in the Supreme Court, because what the Supreme Court was saying, even if a developer has met the public interest test, if it has nevertheless committed and it created a new, I think a relatively new legal concept of a cynical breach. If it had created a cynical breach, then it wasn't going to benefit from the removal of the covenant. So that's what the Supreme Court were looking at.
And Paul, that has ramifications and implications for developers, but also for Mr. and Mrs. Smith in their property that's subject to a covenant. Again, the sort of their conduct and the bigger picture, as it were, could cause them problems with regard to the Section 84 application.
Exactly. So, to be clear, this case, the Supreme Court case, was just about the public interest test. Yeah. But what the Supreme Court held was that the exercise of discretion, i.e. how people had behaved, applies to all those other sorts of restrictive covenant issues and applications. The one that's most likely to occur in a residential context is going to be whether there's some material benefit.
Yeah.
So in that case, a neighbour might be able to show that it would be okay to remove the covenant because of the material benefit test or whatever. But if it's behaved awfully in doing that, and I don't want to go through a list of what awful behaviours might be, but I'm sure many property lawyers will have come across them. But if they behaved awfully, then that will be weighed very heavily against them. So a couple of the sort of key quotes, because I think one of the things that might be weighing on the mind of people advising their clients is, you know, how bad does the behaviour have to be?
Yes.
How cynical? You know, what can I get away with, or what can't I get away with? And the sort of the mildly unsatisfactory answer to that is, it's a bit like the well-known elephant test. Is you know cynical behaviour when you see it, and that's really what happened in the Supreme Court. And I'm going to do a couple of quotes here for the moment, just short ones, which is when the lead judge was giving his summary on the Supreme Court case. He said that, you know, he understood what the upper tribunal had done and how it had done it, but then he said something had gone fundamentally wrong with the tribunal's exercise of its discretion on the facts of this case. Now that's the Supreme Court, without particularly showing any detailed working, saying this just doesn't feel right, this looks wrong. So advisors who are doing a good job for their client will need, firstly, to themselves to ask themselves that question, does this feel right? And then to have quite a good conversation with their client. And the legal point that we put on our side, and I appreciate it's been said, we acted for the winning party. We were part of the team that acted for the winning party, a great set of barristers as well. But one of the points that was put on behalf of our client, and which the court quoted with approval, was, it's not in the public interest that a person who deliberately breaches a restrictive covenant should be able to secure the modification of that covenant in reliance on the state of affairs created by their own deliberate breach. So that's the sort of thing that, you know, sounds like legal principles 101. You just can't take advantage of your own wrong. What the Supreme Court did say, to modify that slightly, and this is against the background that courts almost, they just don't like saying never. They never say never. So what it said, it didn't say a party who has breached a covenant and then come and given us this fait accompli will never be successful. Didn't say that, but it did leave the implication that it would have something of a mountain to climb if it in fact done that.
So Paul, it's interesting, isn't it then? So from a solicitor's perspective, from a transactional property lawyer's perspective, what we've got to say to ourselves is, if we're ever faced with thinking about Section 84, it's prudent to do quite a bit of, pardon the pun, digging with the client around the history of the matter, just to see what's gone on, what their thinking was, and then to gather, as it were, ammunition to gather evidence, just in case these sorts of arguments are found when we get to tribunal, or, you know, if heaven forbid, beyond that. Yeah, that's got to be the point, hasn't it?
Yeah. So I sort of, in the course of this and of the case, and for this, I've sort of, because all of these restrictive covenant cases they're all individually unique. They all have their own relationship. They all have their own facts. But I thought it'd be interesting to just draw out where the developer here had gone wrong, as a sort of set of negative role model points. So these are the things that the developer was shot down for in this case. I think I've got 6 here, which is, firstly, they although they knew or could very easily have known who had the benefit of the covenant, they deliberately chose not to engage with them. So the developer turned a blind eye to it.
Yeah.
Secondly, my client wasn't the only party that had the benefit of this covenant. There was another party who did go and try and talk to the developer. And despite the fact that someone had gone to the developer to say, hang on a sec, you're building in breach of this covenant, Millgate didn't down tools at that stage. It just carried on. So that's,
right.
you know,
Yeah.
even once they've been engaged, they carried on. The third thing was they could have structured the development so that it didn't breach the restrictive covenant.
Right. Yeah.
There was quite a wide development area, and only part of it was subject to the restrictive covenant. And what they did was they built on it, whereas in fact they could have just built on the other land. So that's I mean, it's up to the client to make the decision about where they want to build, but it's up to us as the property lawyers and advisors to test that and say, well, you know, is there a plan B here?
Yes.
The fourth of my points about where the developer went wrong is that they only applied to vary the restrictive covenant once they'd finished the development. So that's clearly an attempt to try and steamroller the tribunal into agreeing with what had happened, you know, trying to give them a fait accompli. The fifth point is the quite obvious one, which is that there was a great financial benefit potentially to the developer in trying to win this way round, because if the developer could just get the covenant removed this way round, then the amount of compensation that would be required to pay wouldn't be nominal, but it would be small in relation to the damages that it could have been obliged to pay if it had to go to court. So that's 5. And then the 6th point is standing back from all those details and really understanding the relationship between the parties. So if this had been a dispute between two substantial, savvy property developers, you know, maybe building rival housing developments, or in an inner city area, rival tower blocks, then there might have been a different attitude that was taken by the court. But, you know, the headline of this case is that my client, the wronged party, was a children's cancer trust. The developer was perceived to be a hard-nosed developer. So somewhere along the line, somebody's got to say to the developer, you know how this would appear, know how this might look, because the court has reserved to itself some discretion. And if it's concerned that there's been sharp practice, then it's going to make it's got room to find really against a developer, even if, as in this case, Millgate had done some things right. It had got its planning permission and so on. So it had done some things. But if it looks like there's a, you know, if the decision doesn't feel right, it's going to find room to find against you. So that's a sort of non-exhaustive list, Ian, but you get the feel for it. Is work through with your client what they've done and what those problems might be.
Yeah. So Paul, there's an interesting point just flowing from that then. If I have the benefit of a covenant, okay, I've got to be careful about the sort of bigger picture we said a little earlier. If I am attempting to rely on a covenant, it seems to me from what you're saying, it's incumbent upon me to notify whoever potentially is in breach, hey, you're in breach, or you're potentially in breach, stop what you're doing.
Yes. Yeah. To be clear, in the Alex Devine case, that issue didn't, in those terms, arise because it's a pretty unsatisfactory quirk of land registration that quite often the benefit of the restrictive covenant isn't noted on that title. So my client didn't know that it had the benefit of the covenant, which is bonkers, but it didn't until the claim was brought against it. But if it had have known, then I agree with you that it would have been at the very least important. I'm not saying it'd be crucial, but it'd be very least important to flag up to the developer that it had got this right, that it was important to my client, and that the developer should stop and or talk or negotiate. So the Supreme Court didn't make that finding in this case, but the analogy is probably with quite a few rights of light cases which have come before a range of courts recently and even this year. And it's pretty clear there that where somebody who benefits from a right of light is aware that a neighbouring development's going on and they might be affected, then there's some duty. I won't say, you know, exactly how much they need to do, but there's some duty on them to indicate they've got an interest and that they're prepared to protect it. So in a sense, what's good for the goose is good for the gander. If somebody with the benefit of the covenant thinks they can ambush a developer, you know, do it the other way, take it the other way around, I'll just shut up until they've built it and then I'll threaten to get it removed. That probably won't work either.
Yes.
That would get as little sympathy as the developer did here. And these are quite often, you know, mildly awkward conversations that we have with our client, because our client wants us to maximize all the angles, make sure you get the absolute best commercial deal, and there therefore might be a sort of a table of how much it's going to cost and so on, and there certainly won't normally be factored into that the litigation risk or having to buy off the other side or whatever. But that it's our job, I think, to bring that to the attention of our clients and say, look, this could go in a number of ways. You know, it's early days, but if you want to try and manage it so that it has a soft landing rather than the extremely bumpy landing that the developers had here, if you want a softer landing, then this is really what you should be exploring. So sort of good behaviour. It's quite
again, I'm just hoping you can hear me. You mentioned about the tribunal and the fact the Supreme Court was willing to interfere with the decision of the tribunal. Is there anything we can learn from that? I'll say that again. Is there anything we can learn from the fact that the Supreme Court was willing to sort of interfere in the decision of the tribunal?
There's probably quite a few boring points for property litigators, but for the property world as a whole and for their clients, the key takeaway is that the Supreme Court showed the upper tribunal a lot of respect. It basically said the upper tribunal is a specialist tribunal. It was made for this sort of issue. In effect, it gave it more deference than it might give a county court in the same situation. It's saying this is a specialist tribunal, a particular issue has come before it which it's qualified to deal with, and it has exercised its discretion. And what it said was, it's going to be pretty rare that even if it would have reached a different decision, that it would be prepared to substitute its discretion for the tribunal's discretion. So I suppose what it probably does, Ian, is make it more important to win in the tribunal on those behavioural points and on those procedural points, because what the appeal courts have sort of said is we're not going to just give you another bite of the cherry for some unspecified reason.
Yeah.
What the Supreme Court could point at in this case is points that it said that it wasn't that the tribunal had reached a different decision to the one that it would have reached, but that in fact it hadn't taken certain things into account at all. So issues that were relevant it hadn't taken into account, and those are errors of law, and so the Supreme Court was confident of imposing its own decision there. But a party in the future should be much less confident that it would get anything other than one bite of the cherry when it comes to trying to put its best case.
Yes. So when you get developers going before an upper tribunal, they tend to take it pretty seriously and go in with all their evidence, etc. Sometimes, again, from a residential perspective, you get people that take the attitude, well, it's only a tribunal, therefore it doesn't matter. What you're saying is, hey, you've got to be careful here because this isn't open season for appeals from an upper tribunal, far from it.
Absolutely. The tribunal will apply the same level of due diligence, and I've seen this in person many times, to a party having to make the correct legal points and also to present itself in the right way, so the behavioural side as well. And it's the jurisdiction issue that we're talking about, and whether it's public benefit where it comes, or public interest when it comes to a large developer, or whether it's material benefit, you've got to make that out. And it's there's a limited degree to which the tribunal will take someone's word for it. I'm not trying to drag parties into a sort of very expensive need for expert advice, but really, if you're going to say this is an extremely expensive breach of covenant, then you need a valuer to say that. If you're going to say this is going to destroy the amenity of my local area, then you need a surveyor to be able to say, well, I've looked at this area, this is completely out of keeping with all the other developments. It's a thin end of the wedge argument. If you allow this, then there will be a heap of other problems that are caused. So it is take it seriously, because more often than not, there will only be one attempt, particularly where funds are limited. Yeah.
Thanks for that, Paul. The next thing I wanted to ask you, Paul, is again, I come at this from a transactional perspective, okay? And if you had a sort of a list of things that you were saying to people, such as delegates today and such as myself, what would you say were the important things that we should be taking away from this decision in connection with transactional work?
Well, all of the above, Ian, but the key points, the key points are, and I'd say that they're almost too generally common sense to, you know, they're almost embarrassing to put. But it's firstly to understand as a whole what the transaction, what the deal, what the problem looks like. Stand back, have a really good understanding of it, and feel free to reality check that with colleagues, or, you know, if there's if there's a valuer on board, really check how that looks, how it plays out, because you know, all of us doing our job can start to tick the boxes for their client, but and that might well involve, I say, a sort of uncomfortable level of testing with the client what their assumptions and their hopes are. You might very well need to niggle into things that the client would think are just, you know, legal niceties. Why do we need to do that? There's, you know, I've heard of Section 84. I've heard of public benefit. This is obviously for the public benefit. It's fine, isn't it? Well, let's so getting to grips with all that. And the second point, I'm you know, a broken record here, is about conduct and behaviour, is being as clear and as transparent that you have played it with a straight bat. If you're acting for the developer, and I mean that this in the sort of the individual owning the, you know, semi-detached house, or the big multinational developer, make sure that there's a pretty good paper trail from you going to the other side and being as absolutely damn reasonable as you can be, showing that you understand what their position is, understand what their concerns are, what adaptations you've already made, possibly, to take advantage of it. You know, it's that active listening thing, Ian. You know, show that you have heard what they've said, and if you can amend, tweak, revise what you're doing, then you will be approaching the rest of the process from a position of strength, and we all want to do that. We all want to, even if we might not strictly have the moral high ground, we want to be able to show that we've got some high ground of some description. You know, even if it's the strategic high ground, that we understand how this might play out, how it looks, and therefore we have been very professional. We've been very convincing from the outset. So again, that can sometimes be difficult for developers to take on board, because there might historically have been some friction with the neighbours. You know, by the time they get to the restrictive covenant stage, if they've got planning permission, I've seen situations where there have been all sorts of terrible disputes, allegations, and so on between the parties. Everybody knows where they stand, but the tough love for developer clients is put that behind you, and be as reasonable, clearly accommodating as you can afford to be, if your true priority is to be able to get this bill, get rid of the covenant, get this bill, and then move on. Because the downside for colleagues or other transactional lawyers is that they'll have to refer to this case as to, you know, what's the worst that can happen? Well, the worst that can happen is this. You get full-page spreads in the law reports in the Times referring your client as cynical breach. And they're in a bad place. So so those are the sort of takeaways. Is
okay, that's fine. So and again, from this perspective, then, Paul, if we look at it from a client that's in a situation where we've identified objective, what they intend to do with, say, a house that they're buying potentially is going to breach a covenant, then what you're saying is A, transparency as best you can, B, communication as best you can, paper trail, absolutely essential, proper advice, absolutely essential from the outset, rather than going down the line and then realizing, hang on a minute, we've got problems, and then trying to reinvent ourselves at a later date. That isn't going to work, is it?
No. So all those things, and the openness, the paper trail can certainly be reinforced, and probably should be, with things written without prejudice to try and basically bring it to an earlier and more commercial end. So,
yes.
you know, on a without prejudice or subject to contract basis, you could well be writing to the other side saying, you know, we've offered you 50,000, 100,000 pounds to release this covenant. We you know, and we've done that on a transparent basis. In fact, however, we think you've got a terrible position, and we think we're being really generous there. And if we went to the tribunal, we think you'd lose horribly. So,
Yeah.
you know, we're really doing you a favour. So you can still be a little bit punchy as far as, you know, maybe to meet your client expectations, or just to bring about an earlier conclusion.
Yeah.
So you can take that approach, but overall, yes, if you're going to try and get the best result for your client, and that's what we're trying to do, is think about it in the round, think about what the downsides are, because it will be impossible to, well, almost impossible to dig yourself out of a hole if you've inadvertently walked into it. The difference in the Alex Devine case was that the developer didn't naively get themselves into the problem. That's a sort of that's why it's a cynical breach, not just a breach. That's sort of defining factor there.
Yeah. Okay. Thanks for that. That's great. Paul, the other thing that I sort of wanted to sort of explore with you is, you know, the sort of advice that transactional lawyers are given in connection with restrictive covenants generally. A lot of residential lawyers don't sort of ask their clients about client objectives. And it's one of the things I always say that you should be at, you know, why are you buying this property? What's the plan? What's the intention? And, you know, a lot of resi conveyancers will say, well, it's obvious what the client's intention is. We're buying it as a home. But sometimes, you know, there can be other motives, there can be other reasons. And therefore, I always say it's important to identify objective, you know, the purpose sitting behind the acquisition. And then to look at covenants to say, well, are those covenants going to impact on that objective? And to what extent do they impact on it? And one of the things I'm quite interested in is something I think you touched upon. The fact that, you know, a restrictive covenant could be protected by a notice on a registered title. But if it is protected, that notice doesn't legitimize, validate, or legalize the covenant, does it necessarily? So the notice is simply an indication from the land registry that someone contends that they have a valid and enforceable restrictive covenant. It doesn't guarantee that that's correct. Do you think that's a fair comment?
Yes, I mean, the sort of opening level of due diligence, and I've even seen people that you know, try and sidestep this, is what does the registered title say? What's actually there? And in if your land is burdened, it's going to refer to the document that created it. It's probably going to recite the relevant extracts from the deed that created it, or the transfer that created it. I think anybody looking at that, I mean, firstly, obviously you're advising a client what it says, but you probably need to dig a bit deeper. Say, well, let's get hold of that original document. It won't necessarily be obvious who has the benefit of it.
Yes. Yeah.
That quite often is the most difficult bit of scoping out a restrictive covenant risk for a client to start with, is if it's very old. If as many of these covenants they were created by the breakup of a larger bit of land, what was that land? You know, who owns it now? So doing those extra bits of due diligence, and then it comes back to getting to know the client, knowing what they actually want to do with the land, and having a risk as to a sort of risk assessment as to what it prevents. So covenants take all sorts of things. You know, there can be covenants against operating businesses, and we've had people approach us about, well, I want to buy it, and I might want to run music lessons from the property. Yes. What do you think? And I say, well, I think you might have a problem, but I think we need to know a bit more about what that involves. You know, absolutely. if you're running a sort of drumming training session full time, then you might be in difficulty.
Good point.
If you've got recorder.
Well, again, I'm just conscious of how we're doing for time. But there was another question that I wanted to ask you, and again, it's this issue about right at the very start of the matter, about getting expert sort of valuation advice in, surveying advice in connection with the covenant and.
Sorry, I've lost you there, Ian.
Oh yeah, sorry again. I think we may have lost Ian. I am conscious of the time as well, Paul. We're sort of approaching 5 to 3, and we do have some questions from the floor. So I'm wondering if you wanted to perhaps wrap up, or if we move straight to some of the questions. Or
yeah, happy to take those, Steve. Thanks.
Fantastic, thank you, and apologies to everyone. If it can happen to Good Morning Britain, then it can happen to Stewart Title Limited, I think. So, but apologies to anyone where we've lost some signal today, and thank you for bearing with us. And thank you to everyone. We've had a lot of questions so far. So if you do have any questions, please do submit them through the questions panel on your control panel. And we can also, if you want to take questions after the session today, or if you want to be unmuted, we can do that also. There's a couple of things I think you've touched on since the questions came in, Paul. But I thought this was quite an interesting one from Mark. Obviously, there was a big part of this case is the sort of the criticism of the conduct of the developer behaviour. Was there any criticism for the charity in not seeking an immediate injunction? Obviously, they weren't aware, I think you were saying, of the benefit of the covenant.
Yes. But, no. There was no criticism of the charity for not trying to get an injunction to stop the works, for the reasons I'd explained before, which is they didn't know that they had the benefit of this covenant and therefore could object until Millgate had finished the development and then applied to have the covenant varied or discharged. Obviously, my client did know that the development was going ahead because it was next door to it, but they didn't know that they were in a position to be able to meaningfully comment on it. So, in other circumstances, and this really picks up the point that we mentioned in relation to rights to light, is somebody who has the benefit of a restrictive covenant or an easement like a right to light and believes that it might be being breached, is at the very least under some obligation probably to put their head above the parapet and make their complaint known.
Absolutely. I think following on from that, because I think the question ties in nicely, if one enters into negotiations with the developer for compensation for the release of a covenant, are they then at risk of playing into the developer's hands by effectively admitting that the covenant no longer, if it ever did, confers any real benefit to the covenantee, and it's really just a compensation discussion?
Well, that's where we need to be very careful about whether the discussion is without prejudice or not. And there's a bit of a tension there, because parties are always encouraged to try and resolve their disputes without going to litigation. But I think what's implicit in the question is, if they're talking money on an open basis, i.e. how much they would be prepared to accept in order to walk away, then that's very likely to be a factor that weighs against the affected party when it comes to the tribunal weighing up whether it protects something of material benefit or not. Because one of the important things to remember is the value of the covenant isn't simply the ransom value. So it's not, well, I could say no and therefore pay me off to go away. You actually have to prove that it protects my view, or it protects my enjoyment of my property, it protects the quiet, it reduces nuisance, all those sorts of things. So there actually has to be something underlying what the covenant protects, and that might well be undervalued, if I can mix up the metaphor. That might be affected if you're saying, well, actually we'll walk away for a particular price. So okay to have that correspondence, but absolutely ensure it's done on a without prejudice basis if you're the person with the benefit of it.
Excellent. Yeah, that's a very interesting point. Thanks, Paul. And thanks, Mark, for both of those questions. Brian asked, so what will the Cancer Trust do now with the benefit of the judgment under its belt? I.e., will they seek massive monetary payment, or is it likely to seek the demolition of the 13 houses? How do you think this will proceed from here?
I think my client's going to think long and hard about what it does next. It's been in litigation about this for, getting on for 5 years. It's had the result a matter of a month. So it's going to consider what steps it takes next. It would be fair to say, because the Supreme Court said it, that the result of the Supreme Court case does not tell any other court what the outcome of any future enforcement steps should be. So there's still, in a sense, an open landscape as to whether a court might award an injunction, might award damages in lieu of an injunction. So again, it's noted in the Supreme Court judgment that after the Court of Appeal case, my clients wrote asking for the houses to be removed. That hasn't happened. So those are all public record points, but exactly how my client's going to proceed, to watch this space, really.
Absolutely, yeah. No, thank you, and thank you, Brian, for that question. Just going a slightly different angle now. Sorry, Paul. So Leslie asks, is it known whether the developer took legal advice before proceeding to build in breach of the covenant? It sounds very much from what you were saying that they just went ahead and bulldozed their way through. But,
they had They'd relatively recently purchased the development site, so what one assumes that at that stage they understood they were buying land that was subject to a restrictive covenant. It's quite a big development, you know, it's quite a number of houses, and it was part. I won't go into the details, but in fact, it was part of a much larger transaction involving development on another site. So, yeah, I'd be astonished if it hadn't got pretty firm legal advice or had taken legal advice about the implications of this covenant and what it might do. Both because I wasn't involved in any aspect of the case at the time, and also because it'd be pure speculation. I don't know what it made of that advice, but one assumes that it probably took a bit of a gamble. That would be my guess.
Yeah, thank you, Paul, and yeah, but thank you for attempting to answer that question as well. Very tricky one there, I think. But one thing we've had a question about insurance actually. So Heather's asked, when would you consider taking out indemnity insurance? If I could bring Robert in actually to this as well. Robert is on the call as well. Because I think there's the when you take indemnity insurance out, and I think there's also about how indemnity insurance develops from here. And you know, there's a lot of people for quite some time have been talking about the agreed conduct angle and how that opens up potential discussions at the beginning. I mean, Robert, I don't know if you want to sort of develop on that.
Yes, Stephen. Yeah, I think you're right. The behaviour has always been talked about for a while now in some judgments and in the Law Commission report on rights of light. And I think for exactly that reason, and also because most developers don't want to have a fight, they want to get the building sorted, they want to get it up and get on with their neighbours, that the concept of agreed conduct in rights of light policies become far more common rather than the wait and see, which used to be the way. And there has been a certain discussion in the last year or so about bringing agreed conduct over restrictive covenants, and we've had a number of inquiries about that. So I just wonder if that is going to be the way forward. And of course, it could then fit in quite well when you're advising a developer that you explain the covenants are there, who has the main benefit of them, and then back that up with agreed conduct to allow you to approach the main potential objectors with an agreed budget and an excess there, but we're having the comfort of insurance at the back of it. So you're probably then, if you can do that, giving your client the best possible advice, they're taking the right action that the court wants, but they do have remedy to insurance funds if it doesn't go right. I don't know, Paul, if you would agree that might be a way forward.
Yes, I mean, I don't see much of this from the sort of initial insurance end, but it is a sort of, there's a balance obviously between trying to protect the parties' interests, trying to get them to talk about these things to start with, and best practice or codes of conduct are generally being welcomed across the board. They're seen as being benchmarks for these things as to how parties are supposed to engage with each other, whether it's before litigation or whether it's in relation to dilapidations claims or, as you say, rights of light claims. So I think it's only to be welcomed if there's some firming up of what the what's expected of the parties before they go down these routes.
Absolutely, yeah. Thank you. Thanks, Phil, and thanks, Robert, for answering the question there. I'm conscious of time, I think we're all the questions are done for now. Ian, I know you dropped off there quite an unfortunate moment. I wonder if yourself or Paul, or both perhaps, wanted to make any sort of closing comments, final comments on the case. So.
if I may, Paul, there was one or two things. First of all, just this idea about, you know, what sort of advice, assuming that we're transactional property lawyers with an issue where the client, we've got the client's objective, we're going to have to think about a Section 84 application. Valuer, surveyor, specialist, litigator to assist us with regard to our tribunal application. Who do we go to first? What do we do?
I would say the lawyer, obviously, but in reality, in reality, I probably want to know what my client's budget and expectations are, because they're all going to vary. And you know, I've talked about the need for some expert surveying evidence about amenity and so on. You know what? If the situation were black and white enough, I might be saying to my client, well, you know, if there's a market for these properties in the area, can you get some advice from local estate agents about what helps a property sell, what doesn't help a property sell, what knocks the price, and so on? I mean, that won't be the sort of Supreme Court standard of evidence, and I don't want to suggest that people are cutting corners, but if they want to know, really, is it worth pursuing to start with, it's those sorts of things that I would start to say.
Right.
So I think it's always worth, you know, maybe you've just bought the property, or maybe or maybe from our point of view, maybe we've just been acting for the person who bought the property, and at that stage we're probably going to know quite a lot about it, so it's probably worth getting on and sort of trying to sort that out fairly promptly as well, because as time goes by, it's all going to change, and you'll be maybe wasting some time and costs there.
Yes, yeah. Okay, and then the other thing that Robert Kelly mentioned, I think the idea that as planning gets more relaxed, these sorts of things are going to be our, you know, a homeowner's means of defence with regard to development. So the likelihood is, I guess, that we're going to see more of this. Is that fair comment? More sort of litigation relating to restrictive covenants or attempting to utilise covenants to protect interest in land?
I think so. I think so, because in the sense that a well-advised client before would have thought, I've got two hurdles to get over here. I've got to get the planning, and then I need to engage in relation to the restrictive covenant. But if I've got the planning, and now, you know, I'm not a planner, but we've all seen the news about the relaxation of permitted development rights and so on. So if that first hurdle is a lot lower, it does put more emphasis onto the second hurdle, and we don't know how that will play out. But what it does do is, whereas people approaching us for the first time before, perhaps before there was planning, we'd be saying, well, either get your planning permission, or from the other side, you know, do everything you can to try and oppose the planning permission, and then perhaps come back to us. Now we're saying, well, think about whether, you know, is that actually going to be a good result for you? Will you be able to oppose it if you want to? So I think it does. I think it moves it up the list of important things for people to consider there.
And do you have any sort of remarks, Paul, to sort of finish today? Is there anything you'd like to say to delegates that have attended, or any sort of parting words of wisdom?
Only really to repeat the sort of looking at it in the round, reality checking it, because this is a difficult area, and if it wasn't difficult, we wouldn't have got to the Supreme Court. And the Supreme Court's given us some answers and some pointers, but quite often that actually just opens up other questions and lines of inquiry. So the main, I suppose the main point I would say is, is for advisors. Look, everybody's been reminded what this problem is and how expensive it can be if it isn't sorted out. Once you've done that, then it becomes, well, how are we going to solve it, or can we solve it? How are we going to buy our way out of it? And thinking about who the right people for that job might be. And unfortunately for lay punters, it might be a team of people, but you do need to engage with that. You need to know people who have been around the block in terms of restrictive covenants. You need to know valuers who know what the issue really is. So not taking it for granted. I mean, we don't, but just not taking for granted that it's just another conveyancing issue. It's not. It's you might have bought some litigation.
Yeah. That's great. Thank you, Paul. Thank you, Stephen. And thank you, Robert.
Thank you, yeah, I'll just tie everything up. So thank you to Ian and Paul for your time today. It was a really, really interesting session. And thank you to everyone for attending the webinar. If you have any other questions, please do contact myself, Ian, Paul, or Robert. If you direct the questions towards me, I will be able to send them to whoever they might be intended for, if that's easier. Once you leave today's webinar, you will receive an automated message from GoToWebinar. If you respond to this email, this reply does come directly to me and I can send any questions on, as I said. You will also receive a separate email from my colleague Robert Kelly, which will contain some notes for today's session and a copy of the recording. So that just leaves me to say thank you again to Ian and Paul. Thank you all for attending, and enjoy the rest of your day. So thanks everyone, and goodbye.
Thanks very much. Thanks, Paul. Thank you, everybody.
Thanks everyone. Thanks.
Bye.
Thank you, Robert. Good to see you all.